Hi, Mark White here from Idaho Estate Planning. I'm the president and founder and chief cook and bottle wash and sometimes take the trash out because that's how you do it these days when you have a small business. With me is Carly Ward, a fairly recently minted attorney gaining a lot of experience and some of it's good even. We'll go with that.
Yeah.
But we're going to talk today, and this is a podcast. So if you're looking for us on the radio, we're not doing the radio anymore. We did that for 5 years, 252 episodes. So that worked really well. But we found that there's some limitations to doing this on the radio. And one of them is there's a really strict structure that you have to follow. And if you know me, you know that that's hard for me to do. So we're now just doing a podcast. So you can, if you're seeing this, you've figured out how to find it. Carly, you're kind of the techno geek on this. Are there some other things that people should know about finding the podcast?
Sure. I mean, it's on all of the major podcast channels. So Spotify, iTunes, Google Play. I think there's a couple of more that we're on. Also, you'll get to see our bright, shiny faces if you find the podcast on YouTube.
Very good. Oh, yeah. Very, very good. And so if you have questions, you're not sure how you found us today, you can always go to the website, right? No, we have these posted so that you can find us also on idahoestateplanning.com. Today, we're going to be talking about DIY or do it yourself. And we're going to try to be fair in how we view this. We've had a couple of situations in the office, some plans that we've looked at that were done by themselves. And then over the weekend, I saw somebody had posted on Facebook. It was actually an advertisement for a financial professionals site. You may know this person, but I won't denigrate them here. And it's not because I would do that, but some people might take what we have to say as not being wholeheartedly in support of, and we'll let you decide that. But the website and the ability to do your own will and other documents drew some criticism. And I don't want to necessarily dwell all on the criticism and how many didn't like it and how many did. You can get on those and take a look. What I wanted to do, though, is address some of the concerns people had about that particular website and the product that it provides. And so, Carly, I think there's some assumptions that people make when they put together this kind of a product.
Yeah. They assume a lot about that it's actually going to be a great idea and that it will solve everything for everybody, and that it's kind of a one size fits all, which I don't know about you, but I don't fit in the one size fits all kind of category for most things.
Well, and so to the first assumption that this is a good idea, certainly for them it is, because they're going to make some money off of that, and that's the way we do things in this country. But to that second one is kind of troublesome for many, many people, and that is, our situations are not all the same. Our family situations aren't all the same. Where we are in our, in our life is not all the same. Our concerns are not all the same. Whether we have a lot of assets or just a few assets, that's not the same for everybody. And that kind of tends to be one of the first criticisms that we have for any particular product, and that is we're all very different, and it's hard to lump us all together. And that's something that we see on the back end a lot, is that we made that presumption. So before we get started, I have notes, and now that I'm not on the radio, I have to look down, and that just seems uncomfortable that I'm not looking at you all the time out there. So a couple of things that we could start with. There's a concept that I've addressed, and if you've seen me in person, you've been into the office, on the radio, whenever I have a chance, I talk about a plan that you design, a plan by design versus the plan by default. And so, Carly, why don't you take the plan by design part and talk about some of the parts of that, and then I'll take the plan by default and explain what the counterpart is if people haven't planned.
Sure.
So talk about some of the basics.
So some of the basics, a trust, a will, mostly a will is a pretty basic concept that everybody's heard of. Financial power of attorney and a healthcare power of attorney are really kind of the basic, like, 3 touchstone documents that, like, if we could, just wave a wand and everyone had those, that'd be at least a good starting point.
Well, yeah, and again, when I say by design, when you do these, it means you did something.
Yes, you went out there with some intention to go get these documents. They don't magically show up.
Correct. And is doing something better than doing nothing? Well, let's talk about that, because many times it is, but not always. Okay. So the plan by design, let's talk about a will first. In a will, Carly, what are some of the things that you get to choose when you do a will?
Sure. You get to choose the guardians of your minor children. So if you have little ones and something happens to you, it's always great to kind of have your first choice of who's going to step in there. Another great thing is you get to choose your personal representative, who's going to take care of all of your business when you're gone. And then the other thing is you can choose to a point where your personal effects go. So if you have heirlooms or anything of sentimental value, you can kind of note who should receive those. Very
good. And that's the only thing about left that I can think of that's left in there is then the bulk of your stuff. So there's the personal items, and then there's like everything else. And in estate planning and in probate, we talk about it as your estate. And we have lots of people that go, I don't have an estate. Estate, that's, oh my gosh, people.
Literally everybody that comes into the office says that.
Yeah. And so I'm sorry, but in the legal arena, when you die, you have an estate, whether you like it or not, whether you're meant to or not. Even if all you have is debts, you still have an estate. Yeah. I know that sounds really weird.
It's not Downton or Tara or anything like that. Like it.
Yeah.
It's your stuff. It's the clothes on your back.
Yeah. This is about what the probate judge, the magistrate, has to deal with at your passing. And that's called an estate. Whether it's big or small, doesn't matter. That's still an estate. So now that's being by design. You went and created a will, and you chose these people. Power of attorney, you chose. Well, we start with the will. I'm sorry, I got to back up. So in the will, you got to choose who the guardians are, and maybe you had a knockdown, drag out fight over who the guardians would be, because you aren't going to let his mother be the guardian, and he's not about to let your mother be. Anyhow.
Yeah, there's always one person in the family where you're just like, anybody but them.
Yeah, if you come into the office, we'll talk about the least evil guardian conversation, because
Yeah.
we're gonna try to find somebody. But you pick that now. So opposite that, all right, opposite that with a will. Now in all honesty, if you have a will, you're going to go through the probate process, okay? But you've set out the instructions. You said, here's who I want to do this, and here's who I want this, and then this is what I want to have happen with this, and this is how everything else is divided. So you were in charge of that, but that's going to go over to the court. We're going to do a probate process, which is it's a court proceeding. It's not quite like a trial. I've seen them become very much like a trial when people aren't getting along and they disagree. But still we'll appoint a judge and give notice to people and all that good stuff. However, sitting opposite that, right, is I've got a will and I go through probate. That's one thing, usually pretty straightforward for the most part, very straightforward. Takes a little bit of time. We've got some things to work through, but at least you've now, you've set that up as to how you want that to happen. If you don't have a will, it's called intestate probate, which is a legal word that we took out of Latin, and what it simply means is you don't have a will. So what are the rules, though, if you don't have a will? Well, one, the court's got to find somebody to be the personal representative. Now, generally, somebody's picked this up and moved forward and applied to the court, so it isn't like the court has to put a notice in the newspaper, go out into the hall. Hey, Bob, you're the personal representative of this case. Well, Judge, I had something. No, come on in. No, that isn't how it works. But you didn't choose this person. This is somebody who felt like it needed to move forward. Here's a cheat. If you don't pick somebody and nobody else steps forward, then one of your creditors has authority to file a probate. Think about that. You might not like that. And then in that process, we follow the intestate probate rules, which generally is everything goes to everything that's community property goes to a surviving spouse. Okay? Is there an issue with this? Well, there may be if this is a blended family situation, right? So let's say that Carly was married previously, and they have kids. She wasn't married previously, and she doesn't have any kids. She has some niece and nephew.
Yeah, one of each.
One of each, and they're really cute. At least that's what she keeps telling us. No, they
I don't
really
force pictures on everybody.
Anyhow, but remarry now, okay, and she dies just like that. New spouse takes all of the community property, right? Not a problem, because that's what most people would do, except that now if the new spouse passes, where do those assets go? Where do the bulk of the stuff that you had that he got, where does that go? Does that go to your children from a previous marriage? And the answer is no. Under the rules, under the intestate rules, didn't have a will, you got to follow these rules. No, they'll go to the new spouse's kids, whether you liked them or not, whether they were nice to you or not. So you disinherited your kids, and now you have new heirs, and that may not be what you intended. So there's a breakdown right there for most people, right? By design, you can say, oh no, I want my kids from a previous marriage. I want them to get the bulk of my stuff that doesn't go to my new spouse, or I want it to go in trust for my new spouse and then to my kids. But if you don't put that in a will, it doesn't happen. So that's kind of interesting. Well, what happens if you don't pick guardians for your kids? Well, if they still have a parent, that parent, unless the parental rights were terminated, and that doesn't happen most of the time, doesn't, a few times, but not most. So then your former spouse will then be the guardian for the kids. But what if something happens to him? Or what if something happens to the two of you at the same time? We had this situation where a couple was killed, 3 little kids. They didn't get to pick who would be the guardians. And so we went through the process and we finally determined some people that would be the guardians. But we have no idea what they thought. Maybe they didn't like these people.
Yeah.
So that's the design default. So if the will is by design, not having a will is the default, and you didn't get to exercise any control. And I can just tell you from experience, it's more effort, it's more time, it's more money. And most people don't want that.
And more fights and more bridges burnt.
Oh, yeah. Yep. I got nothing to add to that. All right, so Carly, that's the will. What about a power of attorney, a financial power of attorney?
Sure. So the financial power of attorney allows somebody to act on your behalf with regards to financial matters, either when you've decided they can do that or when you're incapacitated. So if you're in a coma, if you are in surgery, if you develop Alzheimer's and you're still alive, but you don't necessarily have the capacity to do something or pay your bills or, sign a contract, you can have somebody do that on your behalf.
So you exercised control. You did this by design. You designed this document that says, if I can't do it, my wife then steps in and she has my power of attorney, and then she can act on my behalf. Really, by the way, a critical document to have in your stack of documents. And let me explain why now. So that's the design. That's by design. I exercise control. I made my choices. Here are the people that I want doing it. If you don't have a power of attorney, then we go over to court and we open up what's called a conservatorship proceeding. And again, since I didn't choose somebody, then the court has to. And these can be really interesting proceedings if more than one person wants to be the conservator. And why would people want to be a conservator? Well, if you have a few dollars, if you have a good sized estate, then they get paid for being the conservator. And so they're in charge of paying themselves. And so this can be huge for some people, especially, for example, we had one where we were talking about the shares of stock in a corporation and who was going to handle those and who was going to make decisions about how the corporation, the path that it was going to take and how it was going to do certain things. Well, that turned out to be very interesting. And so the court does this and somebody initiates a conservatorship proceeding. The judge appoints somebody and the judge then is in complete control of this. The judge gets to decide. So if the loving nephew who doesn't really have a job, maybe hasn't had a job, maybe doesn't have really good training, if he wants to be the conservator, you got a judge who might not be as inclined to make that happen. So But it will be somebody that you didn't choose. And now the conservator is subject then to the ongoing jurisdiction of the court. Will file annual reports, tell the judge about income, appreciation of assets, how much were used on your behalf. So you didn't design it, you didn't exercise the control, and so the default plan is back in the court. By the way, conservatorship doesn't take forever, but it is very expensive. And it involves doctors and a number of attorneys. And then again, the ongoing jurisdiction of the court. Now you can avoid this if you do what Carly was talking about, and that is design, properly execute a power of attorney.
Yes. Also, if your spouse is going to go missing, presumed eaten by a tiger, powers of attorney are important.
Yeah, really, really good. Make sure that we get some things cleaned up.
Yeah.
So that's power of attorney. Carly, it's similar, but what about a healthcare power of attorney?
Sure. I mean, it's very similar. It's just on the healthcare end of decision making, that someone can make healthcare decisions for you if you are unable.
And again, if you're creating the power of attorney, the healthcare power of attorney, you're choosing the person that does that. Now, the flip side is on the plan by default is that we'll head back over to court and we'll come up with a guardian who will then make sure that those medical decisions and the caregiving decisions are made. Again, this person will then will be subject to the continuing jurisdiction of the court and do annual reports. And again, may or may not be the person that you want it to be. And so by design, you pick and choose. By default, you let it happen. I can't count the number of times when there wasn't a power of attorney, when, oh my gosh, it would have been so much more helpful, much easier if we had. So that's kind of the by design, by default. All right. So we're not even talking about DIY. Well, maybe we are. I mean, you could argue that if you don't do anything, then you're doing it yourself, right? Here's my do-it-yourself decision. I'm not doing anything. Most people don't like the results. Now, does that mean that you always need a will in every situation? We've done a few without a will because there weren't major assets. But you know what they had the benefit of? They had the benefit of talking to us and asking, okay, so what if I don't do a will? And we could say, you know what? There's a few things you've done here. You don't have to do a will, don't have to do a probate. It'll be all right.
Yeah.
I haven't gotten there with the power of attorney yet. If you don't have power of attorney, we got an issue.
Yeah.
Okay, so that gives us a little bit of context. Let's move forward then, and we're going to try, Carly and I together, try to come up with some positives that come from doing it yourself. Because in an effort of full disclosure, as estate planning attorneys, this is what we do. And so, would we be strongly recommending that people do it by themselves? Okay. The short answer, of course, is no. From a business decision, that doesn't make a lot of sense. So you can walk away at this point and say, well, they're not going to give me the straight scoop. You can listen and say, well, I didn't like what they had to say because they're prejudiced. That is absolutely fine. But hang on, let us talk, and we'll try to be, even-handed in our discussion of, what can happen with do-it-yourself, and when you might not want to do this yourself. Okay, so first of all, for the most part, if the do-it-yourselfer is not doing anything, like we just talked about, I can't recommend that. Like the great majority of those situations are not made better by not having doing a will or a power of attorney or healthcare power of attorney. So you know where we stand. All right. So Carly, I talked to you a little bit ago. What do you got for saying, yeah, well, it's good that you did it yourself, or it's good that we have that option? What's your best argument?
Well, you tried. You did something. You at least thought about it. You put some thought into what would happen, and tried to kind of mitigate some issues. It's better than, denying all reality and just hoping for the best, or, hoping you live forever.
So for those of you that don't know, Carly is a softballer. She plays softball. She coaches softball. Been doing that since what? You were like 3 or 4?
5, but yeah.
5. I got to get that right. So this may be like getting the bat, going up, stepping up to the plate. At least you tried.
Yeah, at least you stood in the batter's box.
Took a couple of good swings or
you just stood there. Swings, you just stood there. It was great. Yeah. You could have walked.
So, what's that?
You could walk. You never know.
Yeah. So, something good could happen. We have seen situations where it was better that they tried than not trying. Okay. Yeah. I will be just really upfront with that. There are situations that were much better because the client made an effort. And one of the areas where this is really key to me is the healthcare power of attorney and the living will. And it just so happens that there's a lot of really good resources around a living will and a healthcare power of attorney. In Idaho, we have a state approved form for those. Yeah. Meaning you don't have to go to the attorney to get some form that they create. No, right. You can download this one.
Yes. You can download this from a site and not wonder, is this reputable? Because right. It's the one that the state recommends.
Got it. Absolutely. So why would you need an attorney in that situation, Carly? Listen, I can just download it. I can write my name in it. I can sign it. Why would I want an attorney on a healthcare power of attorney or a living will?
Knowledge is a great one. You can ask us questions. We're a little bit more responsive than Google when it comes to giving you the answer to the question you asked.
Well, wait a minute. I can't remember what I was looking for over the weekend, but I noted 670 million hits. Now, that's not 6.7 million. It's not even 67. It was 670 million hits.
And yeah, what are you supposed to do with that?
Well, yeah, how do you go through all that information and make some sense of it?
Yeah.
And a lot of it is absolutely the same. I get it. So what do you put? 435 million sites said X and only 225 million said Y. Therefore, X must be better than Y.
Yeah, that's a really big pro-con list.
Yeah.
Yeah.
Yeah. So yeah, I think counseling is clearly something that you should be able to look to your attorney for.
And we speak English most of the time.
Yeah.
Occasionally it's Latin, and if you're talking to Mark, sometimes it's French.
Yeah, sometimes. I know an attorney in town who says that actually he spends more time with a healthcare power of attorney and living will It's 45 minutes to an hour talking through that and what it means.
Yeah.
And
Because
so
these impact your life. Like while you are alive, they impact your life, your quality of life, what your future looks like. Where a will, you're already gone.
you're gone. You're done. We don't care. No, we do care. Actually, both of them also impact your family after you're gone. But there's something about that healthcare power of attorney in a living will that is a really emotionally charged situation. And there's some really emotionally difficult decisions that need to be made. Now, you cannot do it and let your kids kind of figure it out. I get lots of dads. I'm sorry, dads, but it's lots of dads who say, well, I'll be gone, so it doesn't matter. I'll be dead. Or it won't matter. And of course, then, fortunately, their wives, the mothers and grandmothers, are going, no, that's not good enough. That isn't going to work. So thank goodness for them, because we men are not always brilliant.
Yeah. That's probably right next to the just take me out behind the woodshed
Oh, God.
comment. That's probably number 2, especially when it comes to healthcare documents.
Yeah. Oh, my goodness.
Like if you want to be taken out behind the woodshed, you got to write it down.
So people are familiar with those situations. We had a number of these a few years back. There was the Terry Schiavo situation where there was not a clear direction on what should happen. Should they pull the plug or not pull the plug? And I know I've had plenty of clients that this has been a very difficult decision for them to make. But it's still, however difficult it is for you, it is less difficult than your kids making that decision.
Or your spouse or your parents.
Oh, yeah.
Yeah.
Oh, your loved ones, the shorthand way of saying that. So this is a situation where do it yourself is generally better than not doing anything at all. Is do it yourself better than getting good counsel and advice on this? I don't know that that's the situation. Can you get some counsel and advice on your own and not have to have an attorney? There is some available. There's an outfit called Honoring Choices. And if you Google that, you shouldn't get 670 million hits.
Yeah. And they're local, which is the great thing. It's honoringchoicesidaho.org, I believe. They're part of the Janus network of nonprofits.
And they can give you, there's some good materials there that you can read through and think about. And you should be in pretty decent shape. And so that's one where I would say that's a good effort. If you do that, and the option is not doing anything, I would grab that one. I think that I would be all for that.
And they have all those materials in Spanish, which is a giant population here. So
very good.
That's also very helpful.
Good. So what about a financial power of attorney? You can go online. It's the 4th Judicial District website, and you can find a fill in the blank financial power of attorney. Is it any good? Well, it's valid if you follow the steps, and that is you got to sign it and get it notarized. It's got to meet the requirements of recording a deed, and a deed needs to be signed and notarized before it can be recorded at the county recorder's office. And a financial power of attorney doesn't always need to be recorded, but sometimes it does. So you've got to meet those requirements. So is there a downside to doing that? Well, plenty of times there is. Is it better than not doing anything at all? I would say,
for the most part, yeah.
I would go 2 thumbs up on If you're not doing anything, I mean, if the only other option is to not do anything, I'd get the power of attorney. And here's what I have to say about that. If you have the right person that can step in and handle that for you, then that's better than not doing anything at all. It's really much better. Is that a complete you'll never have an issue with that power of attorney? And the short answer is no, that's not true. But you know what? It'll cover quite a few situations. Again, if you have the right person, yeah, he or she can make it work. So that's okay. There are plenty of situations, though, that are a little bit more involved, a little bit more complicated, that form doesn't address. So while I would say if your option is to not do anything, get it, sign it, notarize it, get the right person in there, I think that's better than not doing anything. Can you do better than that? Well, if you're able to, the answer is yes, because there's some provisions that are not in there that you might like to have. And let me explain one that can come back to haunt you, and that is if you are in a situation where you need long-term care and you don't have the ability to private pay long-term care, which, by the way, is not unusual, starting at about $4,000 a month and goes up to $10,000, $12,000 a month for skilled nursing. It might be hard to pay for that. So one of the options is the Medicaid benefits. And there's some very, very specific requirements to be eligible for Medicaid. And there are some things that you can do at the time that you apply. There's some techniques. However, if you don't have that provision and authorize your power of attorney to do that, you can't do it, you won't qualify for the Medicaid. And I'll tell you what, it's going to be a tough situation. One of them is that you'll have your assets will meet the qualifications, but then your income does not. And if you have just a little bit too much income, you won't qualify for Medicaid, but you can't qualify for anything else either. So that one is a really, really tough situation. There's a couple of more. So I don't know. Powers of attorney are one size fits all. All right. So Carly, what about just your will?
Your will.
Yeah. What about DIY wills, do-it-yourself wills?
Sure. So a couple of months ago, I went and I created a will on a bunch of DIY free sites where you just answer questions and it fills in the form and gives you a will. And it was really interesting to see what came out, what types of wills came out. There was everything from like a 2-page will to, one that's 15 pages long. But for the most part, all of those do-it-yourself wills are trying to appeal to like the lowest common denominator of people and situations that they'll have in common. So it's really hard to customize them and adjust them for your specific situation and your family's needs.
So, and you know what, that doesn't surprise me that they're not easily customized for a number of situations. And I can think of a couple of reasons why that would be. One is there are some provisions that to make them work, they have to be said in a very specific way. And those programs can't put that specific in there for everybody because they don't fit everybody. Now, and the other part of that is that people that are answering the questions don't know that that's the one that they need. And so you're taking on some liability, I would think, as the programmer, to put that in there and not have a way for people to check the right, the right box. That would be very difficult to do. And so that's why it would be, hard to get that kind of customized level.
Yeah, even I answered some of the questions wrong, and I went to law school, I passed the bar, and do this for a living. So they're not always intuitive when it comes to what the questions are. I mean, so it's kind of hard to understand exactly what you need for your family and to be able to answer those questions correctly so that you get the right provision.
Well, it just so happens that the law isn't always intuitive. And so coming up with the right thing all the time is a little bit, there's the school learning that you have, and then research that you do, but it's hard to make up for experience because not everything works just the way you think in your head it will work. And so to be able to put that into a program is difficult, and to be able to program in the right questions that get people thinking in the right way to answer that correctly can be very difficult.
Yeah,
So,
it was super basic stuff like, do you want a guardian for your minor children? And do you put in your spouse? Do you want them to have guardianship? Or do you then just jump to your sister and brother-in-law right off the bat? Like, it doesn't explain exactly which situation you should pick.
yeah. So that's a real challenge with the program, is that they want it to apply to a whole bunch of people, like anybody that bought the program. And not everybody has, like you were saying, the requisite schooling and then experience to know how it applies and how to answer fairly basic questions. We're going to have to shut it down for today because we got a lot more to talk about, and we are out of time. And I think as we roll forward, people look at it and be able to say, oh, well, I can see where those you wouldn't want to do it yourself. And so, we'll pick up that discussion. So again, this is Mark White with Carly Ward, Idaho Estate Planning. Good to have you along. Hope this gave you an idea about do-it-yourself. Don't want to discourage all of it, just some bunches of it. Have you, if your situation is just a little bit out of the ordinary, which many are, even though you kind of think they're not, visit with a qualified attorney. And Jess, you could always call us. We're right here. You can call us. We'll visit with you.
Yeah. I mean, we can understand your situation and be able to help you kind of navigate those situations. So I'm going to log off here. Kind of a bummer that Mark ran into some technical difficulties, but we will see you next time.